Welcome back. I'd like to welcome our next moderator, Professor Brett Frischman from Villanova University's School of Law to the stage. Brett, thanks for joining us today. Feel free to introduce your panel as I add them to the stage.
Sure. Welcome, everyone. It's a pleasure to be here, and I want to thank all of you for attending, and we're going to have a great conversation. It's fun. We've had a superstar bunch of panelists. So they had asked me if you want to be a panel or a moderator, or you want to be a panelist and a moderator. And I said, I looked at the list and I said, we got too much talent. So I'll just be a moderator. So we have, I'll just introduce them in alphabetical order, or I guess they're going to pop in alphabetical order. We've got Kevin Amer for the Deputy General Counsel for the U.S. Copyright Office, Bob Brandeis, the Professor of Law and Co-Director of the IP program at GW, Terica Carrington, VP Legal Policy and Copyright Counsel at the Copyright Alliance, Colleen Chen, Professor of Law at Santa Clara University School of Law, and Karen Temple as the SEVP and Global General Counsel at the Motion Picture Association. So you have their bios and elaborate backgrounds, and so we're not going to do more than just that brief introduction. But like I said, absolute superstar set of panelists. So this is fantastic. Now, before we've introduced the panelists, by the way, I'm gonna look at hit the Q&A tab open, but I'm not going to be surveying the chat. Feel free to use the chat, but if you have a question for me or the panelists that you want to raise during the conversation, just pop it in the Q&A and enter your question there. You can ask it there, and I'll try to include them as I can. So I want to first open by introducing our panel topic, which is pretty interesting. So it's IP as social change, reconceptualizing the rights holder /IP consumer symbiosis after georgiavipublicresource.org. Now, I mean, that's quite a long title. It is, even the use of the colon, it is totally a law review editor's kind of a law review article title from like the 60s or 70s or 80s. I was surprised it wasn't like a 2-word title, but I blame it on the law reviews, right? So this is, the law reviews have influenced our organizers and given us this incredibly long and complicated title. But there's a lot that we can work with, right? There's 3 parts. Each of which provides a useful opening for our discussion and for warming up the speakers and the audience and to sort of get us chatting. All right, so first, the first thing is I want to get the panelists, give the panelists the opportunity to explain how they view just the first bit, right? IP as social change. I'm willing to sort of extend it a bit to sort of maybe to cover IP and social justice more generally. So we'll just go through each of the panelists, and I want each of you to just, how do you think about that relationship, IP and social change? What does that bring to mind? And if you can relate that perspective to the work that you do, that would be a bonus. So why don't we start with you, Kevin?
Well, thanks, Brett. It's obviously a huge topic, and I think the Georgia case obviously presents a really fascinating lens through which to view the topic. I mean, obviously, we at the Copyright Office, think copyright is very important to sort of encouraging social change in a beneficial way, allowing authors to be incentivized to create works that can benefit the public as a whole. Obviously, at the margins here with a case like the Georgia case and cases that I'm sure we'll talk about involving sort of other types of works that are maybe privately authored that are somehow used by the government, it becomes sort of a more complicated question in terms of, to what extent does the creation of these sorts of works depend on the incentive structure that the copyright provides, certainly in the private sector? And so there are a lot of really close cases, I think, at the margins. The Georgia case, I think, certainly was a challenging case. We worked on it in our office along with the Justice Department. So I'm Yeah, happy to turn it over to the others to get their perspectives. But, from our perspective at the Copyright Office, we certainly think that copyright plays a hugely important role in encouraging social change in a positive way.
Wonderful. All right. So yeah, and we'll dig into don't worry, we'll get to that case. We're going to dig into it a lot. But before we do, again, Bob, tell us what you think of when how do you see the relationship between IP and social change?
Well, I'm going to IP and social justice invitation right off the bat.
Okay.
And I guess from the creator side, I'm interested in understanding whether there are quite different patterns and rates of creation on behalf of different groups in society. So Totan Oliar and I wrote an article a couple of years ago trying to take a look at the copyright registration database and seeing what percentage of various types of works were authored by gender, by women versus men, and by race. And we found huge disparities. That's really only asking a question. That's not providing an answer. But the disparities should cause us pause at least and think about what outside of copyright and patent and trademark doctrine might be leading to these disparities in IP creation and IP ownership, and possibly what inside doctrine might be leading to these disparities. And kind of on the inside of copyright doctrine side of things, I wrote more recently an article called Copyright, Race, and Mirror Cover Recordings, in which I explored the possibility, in fact, I argued, I should say, that the shape of copyright doctrine as decided in a court case in 1950, but later incorporated into the Copyright Act itself, sort of preferred certain creators over others. And in particular, in the context of the early 1950s, ignored creativity by African-American musicians and arrangers in the musical world. And so, when I think of IP social justice, I worry about certain doctrines that may have different, disparate impacts, particularly on minorities in our society. So that's my first take.
Oh, great. So to sum it in a quick way, it's almost what gets produced qualitatively and by whom.
Yeah, I think that's right. I mean, we could go on the audience side or the access side. There's a whole other line of inquiry, but I'm going to leave that maybe to one of the other panelists.
Sure. Tarika, can you tell us about how you conceptualize or you think about the relationship between IP and social change, or IP and social justice more generally?
Yeah, definitely. So I'll follow Bob's lead here, and I'm actually going to extend the question to IP and social justice as well. This is an area that really excites me about IP and, specifically copyright, because that's the area of IP that I focus on. Owning property is such an important part of the ability to thrive in this country, because it carries with it a certain degree of freedom, a certain degree of autonomy. And historically, as we all know, certain groups have been marginalized in the area of property ownership. Black people for hundreds of years were considered to be property in this country. Native Americans, had their land literally stolen from under their feet. Also, other people of color, women, there was a long time where women, to some extent were considered to be property of their fathers and property of their husbands, and actually had restrictions on the ability to own property. So what excites me about copyright in particular is that it opens doors and breaks down barriers for groups that have historically, had barriers placed in their way that stop them from being able to own property. And what I think is especially great about copyright is that the barriers to entry are notoriously very low. There's a low threshold for originality. Ownership is automatic, so you don't have to pay in order to be a copyright owner. Of course, there are benefits to registering a work, but there's no financial barrier as far as actually being able to be an owner. And I think all of that really matters because marginalized groups generally have less resources to invest on the front end for property ownership. And I think copyright is great because it literally allows someone to turn an idea into a property right. And so, that's the connection that I see between copyright specifically and social justice.
Oh, that's great. And there's a rich literature and like approach to thinking. That's a great way to sort of connect the two, I think. Colleen, you're up next. IP and social justice. You can do copyright or you can do patent or whatever else you like.
Well, it's just a pleasure to be on the panel today. And I think a lot of my comments will echo what has already been said, but I tend to think about the social justice and IP question, again, extending it into that realm. Right now, I'm really focused on inequality and thinking about sort of what are the mechanisms by which IP can both amplify, but also alleviate inequality. So I think we've already talked about, and typically when we think of inequality, we think about income differences or wealth. But I think when you're talking about IP, you really want to focus on two types of inequality, that being equality of opportunity to participate in a lot of what Terica mentioned, transform your labor into capital, and then equality of access to the innovative works downstream. And I think I'm going to take Bob's invitation to ensure that we talk about access questions as well. And I think IP can be very instrumental in both areas, but also be something that we need to be concerned about. So on the front end, with respect to equality of opportunity, again, from the patent side, I think there's similar types of concerns about, especially since patent barriers are a lot higher for registration, the ability of people to participate in the patent system. So great work that Lisa Cook has done and others have documented the historical exclusion. You can see it in the statute itself, but also even access to patent lawyers and the segregation that kept Black inventors sort of away from the machinery and the social capital needed to actually access the patent system. So in the work where I talk about sort of equality of opportunity, I talk about innovation capital from a human dimension and all the people that need to be involved. Not only in getting and acquiring the IP, but then enforcing it later. And Latifah's written a lot about sort of the importance of IP and social justice in terms of not only getting the IP, but actually being able to enforce it and actually being able to get the value of it. So in the patent system, again, we have huge barriers not only to getting the right, but then also enforcing it downstream, which has led to a lot of issues. But I think it's ultimately for equality of opportunity, we're talking about a social mobility story. How do people, are they able to use IP to help improve their economic outcomes and do better? And so I think on the access side, I'll just briefly say, I think there's also important use of IP with respect to being able to do differential pricing, offer innovative goods to different levels and different abilities to pay. So I think that's where social justice and social change can really come into play.
Great, and we're certainly we'll dig into the differential pricing for sure when we get to talking about some of the concerns in the Georgia Bureau case. So that we'll come back to that for sure. And Karen, last but not least, your perspective on IP and social justice. And if you feel like it's already been covered fully, I could set you up for the rights holder IP consumer symbiosis question.
Well, I will say that it is difficult to come in as the last one because I do think that everyone really touched upon a lot of the issues that I would have highlighted myself. I would say that there are two issues that I did want to add to the discussion. Just going back to the constitutional foundation of the IP clause and the fact that our founders thought it was so important that it was in Article 1 of the Constitution. I think that shows how important the intellectual property system has been seen over the years and over history in terms of empowering communities and society. And so the first I would say is just that the goal of copyright, as reflected in the Constitution and as the United States Supreme Court has said, is to, and I'll quote Mazer versus Stein, one of our favorite cases, is the conviction that encouragement of individual effort by personal gain is the best way to advance public welfare through the talents of authors and inventors. And so I think, again, the goal of copyright as advancing public good, advancing public welfare is fundamental to the IP system and to copyright in terms of its constitutional foundation. And then the second, going away from the general public welfare and public good that copyright reflects, I would say for individuals, as we've discussed, and I think as Terica highlighted, the economic, the way that we advance that public good is through the economic incentive. And I think it's very important, and I think we'll get into that a little bit in talking about the public, versus private, issues with respect to copyright. But the economic incentive is something that is very important in terms of authors and inventors. And I often, when people discount the importance of having that economic incentive, I often wonder, well, what would be the alternative? Do we want to get back to a society where the only works that are created are works that are created through some type of artistic patronage of the previous centuries, where you have just a set number of wealthy elites being able to control and decide what is produced? Or do you want an incentive structure where, regardless of whether who you are, or whether you have your own ability to become a patron, you are able to contribute to society? And so that's, again, where the economic incentive for the individual becomes a really important part of not only copyright, but ensuring that the goals of copyright in terms of being a public good are met.
Okay, great. So within all of those comments, I hope the audience is picking up on, we've got a bunch of different conceptions of social justice that are overlapping, but are not always the same, right? So they kind of connect, and we'll kind of unpack that as we go through the examples a bit more. What I want to do is jump to the second part of the title, which just sets us up beautifully, is they asked us to reconceptualize the rights holder IP consumer symbiosis. And I'm not sure I even know what that means, to be honest. So I wonder if we can conceptualize it first, and then we can figure out whether we need to reconceptualize it and how. So I'm wondering if any of the panelists, I'm not going to go through all of you on this one. Can someone conceptualize the rights holder IP consumer symbiosis? Or maybe there's multiple out there we want to hear. Who's going to volunteer on this one? Don't make me go Socratic.
I'll start on this one.
All right, Derek.
So it's interesting, in preparing for this panel, I actually took a look back at the definition of symbiosis. It's been a long time since I took biology, so just want to do a little refresher there. So a symbiotic relationship is an ongoing relationship between two organisms. And so for the purposes of this panel, those two organisms would be, on the one hand, the universe of rights holders, and on the other hand, the universe of IP consumers. And so this is the part that I really had to brush up on. So there are actually various types of symbiotic relationships that exist. I think there's like 5 or 6, but I'm just gonna highlight 2 that I think are relevant to our discussion right now. The first one is mutualism. And so that's a relationship that's mutually beneficial to both organisms. And I think that's the goal. That's where we want to be. And I won't jump ahead, so I'll just leave that part there for now. But I think, unfortunately, in my opinion, we are closer to parasitism. We're closer to more of a parasitic relationship, which is a relationship in which one organism benefits largely to the detriment of the other. And I know that probably sounds kind of harsh, so let me explain what I mean. Creators are constantly struggling, and especially individual creators and small businesses, they're constantly struggling to stay afloat. They deal with rampant piracy, they deal with infringement, sometimes to the extent of having to actually close their businesses or stop creating altogether and find alternative career paths. And then oftentimes when they are infringed, and if they don't want to exit and find another career path, they struggle to even be able to afford to enforce their copyright in federal court because it's so expensive. They deal with not being fairly compensated. They deal with platforms and intermediaries who are pretty much benefiting and making a killing off of the backs of these creators. And so you begin to see a relationship between these organisms that's not quite mutually beneficial the way that it's supposed to be, and I think the way that it's intended to be. So, if you were to ask me my conception of the relationship as it is now, I think it's on a continuum. I wouldn't say it's exactly a parasitic relationship, but I would say it's definitely more close to that than I think it should be. And I think the goal is to move more closely to a mutualistic relationship.
Well, that's a very useful way to frame the possibility space for what the relationship could be. Whether we are currently more or less parasitic than is optimal, whatever that might mean, is debatable, right? So I wonder if any of the other panelists want to jump in on that, or should we on what the symbiosis is, or maybe where we are currently.
Yeah, I would add to that. I agree with Terica in terms of just some of the concerns, and I think and I alluded to this a little bit in my earlier discussion about the economic incentive, and that is sometimes when you talk about IP or copyright specifically, there's this I think attempt to use rhetoric where they pit the public good or the public against authors, as if they're as if copyright somehow is against the public good and social justice, if we want to get even more specific. And that I think that really does a disservice to again, going back to the goals of copyrights, because you do really want to ensure that there is not a parasitic, as Terica would say, relationship between authors and those who are being able to take advantage of their works, but that authors are actually incentivized and can create more. And when that incentive is in some way imbalanced, either through piracy or some other force, then authors themselves are not able to create as much as they would otherwise be able to create. And then, of course, the public good that copyright is supposed to generate, the public welfare in terms of, knowledge and scholarly works and just overall creativity and storytelling, is then lessened. So I think, again, you have to ensure that you do have that balance, that there is, a balanced situation between making sure that you have access by the public to these works, but that creators are in fact incentivized by being able to control and, receive the economic benefit of their works as well.
So if we were looking for reconceptualizing this relationship, I can think of at least one to start with, which is to suggest that it's a false dichotomy, right? As if the distinction between authors and consumers is a necessarily sharp one. That's one, and I'll just throw that out there for I'm not a panelist, I'm a moderator, so I'll just throw that out there for you all to riff off of as you will. But I imagine there are others. So are there ways, if we're being asked to reconceptualize it, and we can dwell too long because we can get to the case, because the case is really the prompt we have for how we might reconceptualize it. But are there other points that you feel like you want to make, any of the panelists, about how we should be reconceptualizing this relationship? Colleen, you look like you're about to.
Yeah, I'm going to just add a point
of
information, which I don't know if it speaks directly to a reframing, but it strikes me, having done I wrote a review in Michigan Law Review of book that Jessica Sibley did, where she interviewed tons of creators, inventors. She asked them, talk specifically to this question about what their relationship is to to consumers and how important is IP in that part. And I think it echoes a little bit of what Karen was saying about the importance of control, but also of credit and having, an audience. And that audience, being able to understand, be able to set the terms of how the audience is able to access the work, which might be in some cases, again, and we'll go to differential pricing, I think, later, at a more, free level, and for others at a level where they can afford then to have a living and have, and thrive and have their protection to do their work. So I think of, again, consumer may not be the right, only other actor to put into the conversation. We need to talk about audiences, and again, being able to differentiate between them in other different ways, not just in terms of a transaction that's a single thing.
Great. I'm looking at your eyes and whether you're all about to jump in, and no one looks like they're about to jump in. So I'll just say
the point that you brought up, Brett, about this false dichotomy, I definitely agree with that, and Karen touched on that as well. And I think, going back to my whole mutualistic, parasitic relationship thing, I think part of what it will take to move the ball closer to the mutualistic type of relationship is, confronting that narrative and pushing back on it, because I do believe that there's much more overlap and much more shared common interest between IP rights holders and consumers, because in most cases, we all hold several different identities. We don't leave all of our identities except one behind when we step into this room, and, you know, and then drop that one and pick up another one when we go into another room. Creators are very much still a part of the public. You know, they don't shed their citizenship and their, you know, public interest just because their career of choice is, you know, a creative career. And so I think pushing back on that and really pushing the narrative that, you know, there is actually a lot more common interest between those groups, you know, is the way to do that.
And I'll just jump in just to say I agree wholeheartedly. I think, again, going back to the whole dichotomy, the public or consumers, if we want to say, versus the author is something, again, that's rhetoric that we really should, not use. And I think that's the best way to reconceptualize it, because as Terica said, authors are part of the public. And so there shouldn't be this assumption that authors and the public have different goals or different reasons to want the copyright system to succeed, because again, I think both sides can and should benefit from a well-functioning IP system, and they're not really even sides. Really, is also the point.
All right, so the organizers suggested, obviously from the title, that, and this is the only panel that has a Supreme Court, that has a case referenced in it, that's sort of framed around a case. So the organizer suggested that the Georgia v. publicresource.org case might be a useful driver for reconceptualization, for thinking these things through. We're going to open it up after we talk about this case to other cases, but let's try to figure out whether this Supreme Court case might serve as a useful driver for social change, and whether or not it is or is not, it's still intriguing, right? Because it's an unusual case, right? Consider the unusual nature of the parties. You've got the state legislature, not your usual private rights holder. You've got publicresource.org. Public Resource is not, they're not really using or consuming IP in the typical way that we normally encounter and associate. So we're already starting with a set of relationships that seem quite different. So in any event, to get us rolling, I'm going to do what law professors like to do, which is to cold call on one of our panelists to make them brief the case for the audience, because maybe the audience isn't familiar with the case so much. So who should I cold call on? Let's see. No one in the Q&A suggest. Why don't I cold call on the person who's used to doing the cold calling? Hey, Bob. Can you brief this case? What are the facts? What are the issues presented? Can you please go through the case for us?
To be fair, I believe you gave me a little bit of warning that I might be cold called. So I consider this kind of a lukewarm call, not a cold call.
Lukewarm, okay.
So as you noted, right, the conflict started when this nonprofit organization, public.resource.org, founded and run by Carl Malamud, posted online several copies of the entire official code of Georgia annotated. And it's called the official code of Georgia annotated because it contains not only the text of the laws of Georgia, but annotations, which, as most of you know, are summaries of how judicial opinions have applied those laws. In this case, they also contain summaries of opinions of the state attorney general about those laws, citations to law review articles, and other reference materials. Georgia's Code Revision Commission sent several cease and desist letters claiming that it owned copyright in the annotations. And when public.resource.org refused to stop distributing the annotated code, the commission brought a copyright infringement lawsuit. The district court granted summary judgment to the commission. The 11th Circuit reversed, and the Supreme Court granted cert to review the 11th Circuit's decision. So in an opinion issued back at the end of last April, the Supreme Court held that the annotations are not eligible for copyright protection, or ineligible, right? The Chief Justice writes the opinion for the court. It's joined by Justices Sotomayor, Kagan, Gorsuch, and Kavanaugh. So it's a bare majority there. We've got 5 votes for the court's opinion. And the opinion takes the position that not only the text of the law, but the annotations are covered by the government edicts doctrine, which precludes copyright protection. So under that doctrine, as the court in this case articulates it, officials empowered to speak with the force of law cannot be the authors of the works they create in the course of their official duties. That's the court's articulation of what this means in this case. how that ends up including the annotation takes a few twists and turns of reasoning, because the annotations are actually written by employees of Matthew Bender and Company, better known by its trademark Lexus, under contract with the Code Revision Commission. However, reasons the court, the annotations are produced under a work-made-for-hire contract. That makes the Code Revision Commission a state entity, their author and the initial copyright owner under federal copyright law. And then in turn, the Code Revision Commission is found to be an arm of the Georgia legislature. And the Georgia legislature, as the court mentions, actually passes a resolution approving the official Georgia, a Code of Georgia annotated as official, right? Therefore, says the court, in fact, it's legislators who are the authors of the annotations. They are exercising their official duties in doing so, and that's all the court needs to know. The court also makes some policy noises about providing the public with access to the law, and not just what it calls economy class access, something I'm sure we'll come back to. Okay, so that's the court's opinion. There are two dissents, each of which interprets the government edicts doctrine somewhat differently than the court. So Justice Thomas, joined by Justice Alito and in part by Justice Breyer, he draws a line between works, essentially works that have the force of law and works that don't, right? So actual laws and government regulations, those are precluded from copyright by the government edicts doctrine. However, shouldn't extend to annotations. Those are mere helpful explanations. None of the annotations have the force of law, right? And Justice Thomas responds to the court's access to the law policy argument with, I think, a classic copyright and as incentive argument. He's worried that without copyright protection, many states will stop producing annotated codes altogether and will be without, nobody will have access to those annotations if they aren't produced. Then lastly, Justice Ginsburg, also joined by Justice Breyer, and I never thought I'd be saying, guess what, in a copyright case, there's an opinion which the only two people who joined that one opinion are Justice Ginsburg and Breyer. But here I am, Justice Ginsburg, joined by Justice Breyer, says that the government edicts doctrine renders uncopyrightable anything created by legislators in the course of performing their lawmaking responsibilities. So that would include not just the text of statutes, right, which is Justice Thomas's emphasis, but also any legislative history materials. During the course of lawmaking, you are drafting bills which may never get passed, you're drafting reports, you're corresponding. All of that, says Justice Ginsburg, should be covered by the government edicts doctrine. However, because legislatures don't have the duty of construing statutes after enactment, and that's what the annotations are doing, they're construing the statutes after the enactment, the government edicts doctrine doesn't preclude copyright in the annotations. So that's the case, the opinion in the court, and the two dissents in a nutshell.
Wonderful. Wow. A+. You got full credit marked down on your attendance sheet for the case briefing. Was there anything about the doctrinal maneuvering that surprised any of you on the panel? That when you read the opinions completely flabbergasted you and you were surprised to see, or was it, well, I'll just leave it at that. Anything that jumped off the page when you first read the decision that you couldn't believe what you were reading? You're all looking at me with like, nope, it was exactly what I expected. Okay, I'll give you guys a chance to think. This wasn't a question I had asked. I given you forewarning about, so you're all looking at me like I'm a law professor who asked the students a question.
There wasn't anything that completely. Was surprised by the outcome in the case and the reasoning of the majority. I was surprised that the court that pulled together those two votes adopted the definition of anybody who has lawmaking power and is speaking in their official duties. That's how broad the government edicts doctrine runs, and the steps that into.
Well, you're breaking up a little bit, Rob. Just I don't know if other people
Okay.
are having issues hearing, but so there's like the principal agent work for hire kind of argument or analysis that the court is relying on that you found a bit, extending it to annotations, you found a bit surprising.
I can jump in and just say, I wouldn't say, I was flabbergasted by anything or anything jumped off the page in that way. But I do think the opinion was interesting in that it really focused on the statutory term author. It decided the case as a statutory matter based on the term author, which is interesting because the struggle, I think, with this area of the law, certainly that we encountered in looking at this case, was the fact that in terms of, at least at the Supreme Court level, the only precedents you had were these 100-year-old cases, which weren't, entirely clear about what the rationale was for the edicts of government doctrine. There's some language in these old cases that talk about the author rationale, that a public official is not considered the author when acting in their official capacity. But there's some other language that talks about if the law is binding on citizens, it shouldn't be copyrightable. And so that, I think was the basis for George's argument that no, the government edicts doctrine is just limited to things that have the binding force of law. Here the court clarified, at least in this context where, something is being created, at least as the court decided it, by the legislature or a court, that the way we analyze that situation is through the statutory term authorship. Now, as I'm sure we'll get into, so that really clears things up, at least in terms of, legislative materials. And it would extend to committee reports, floor statements, draft bills, and so forth. It does leave open the question about other sorts of materials that governments may rely on or incorporate by reference or adopt. The authorship framework, I think, doesn't really work necessarily in those cases because, at the time of creation, the author is not a government agency. It's something that happens later on where the government ratifies it or endorses it somehow that calls into question, whether the copyright persists. So I think just as sort of a doctrinal matter, it was interesting that the court sort of was very clear that it was deciding this case just as a statutory matter based on the definition of or the term author.
Right. So Kevin, you just laid out, in a sense, one way of seeing how the doctrine maps onto the conventional access and incentives set of arguments, right? So the access arguments one would make have to do with if it's binding, if it's law, we must follow. It has the force of law. We all must have access to it, right? And so there's a push, an argument that you can that goes in that direction. On the other hand, on the incentive side, if it's the government within the scope of employment of a government official to generate whatever the expressive content is, right, that would otherwise qualify for for copyright. The incentives are, you don't really need the copyright incentives to generate that work in the first place, given that the person's fully employed, paid by the government to produce exactly what they're producing, which tees up this, again, this case is a nice way to tee that up because it's kind of a weird case because it's kind of a little bit of both, but neither of either, right? Because we're talking about annotative creativity, right? And so in one sense, so this is just to jump to one of the set of arguments in there.
Well, before,
go ahead,
it sounds like
Colleen.
we're going to maybe talk about other topics as well, but just I wanted to add upon a couple of points that Kevin made and also made earlier. I mean, I think there's two things to me that are really striking. And I know part of these, I'm going back to when I was in the White House and we were talking about sort of open data, open access to government works and how we would clarify that. But one thing that strikes me is the fact intensiveness of the determination of whether this is, considered government work or not, having to go through work for hire and figure out, who actually contributed to this, what did the contract say? And I think that's one of the big issues when you're talking about government works. A lot of times, the kind of promise that government works will be in the public domain can't be necessarily checked when you have government contractors. So that's one area, is just clarity about what is the status of the work. But I also think there's an access to justice question with interpreting the law. And so I'm not necessarily saying that those who create footnotes or headnotes should not be compensated, but I work also in criminal justice, and I do a lot of statutory interpretation of laws around expungement, and they're so complex, so complicated, and having access to just the information is extremely important for people to be able to understand how to access the law. And we've talked here about the high cost of enforcing the law. I think there is a lot to be said for access to that extra information, how we get it created, whether it's by a government entity, or it's by a nonprofit, or it's by profit-seeking entity. I mean, I think there are strong arguments that we want that information to be available as part of access to justice.
I would just add on to that. I mean, I think it's, it is really interesting in terms of kind of the access versus incentive issue. And, are we going to focus more on the incentive aspect of the case, or more on the access issue? But I think that, that's where you kind of get into, if you look back at kind of the, economy class versus first class discussion of the case. I mean, I think you can ask the question, by destroying an incentive, are you actually preventing access in some sense? So the court in the case was saying, look, we don't want a situation where something is created by the state, but only people who can afford to purchase this annotated guide have access to it. But if you destroy or undermine the incentive, then it might not be created at all. And I think in the Copyright Alliance, so Terica might want to jump in on this, but in their brief, they talked about, or gave an example of, the Pennsylvania government that actually did not, have any type of copyright protection over the works that it created. It tried to do it all through kind of government funding, but ultimately, because obviously governments don't have significant amount of funding, there's a lot of bureaucracy, they weren't ever able to produce a work at all. So again, you do want to make sure you have that access, but I think unfortunately, by saying that you should cut off the incentive to create access, you might actually cut off the creation of the work itself. And so that I think is part of the struggle that the court was having as well.
Yeah, and if,
right. So
I was
there's
just going to say, if I could just
go ahead, Terica.
Piggyback on that a little bit. I think sometimes when we talk about access, a lot of times what people mean by access is free. And I don't think that's what access actually means. I mean, what Georgia did here by contracting with Lexis to get these annotations written, number one, they contracted with someone who has, a team of researchers, experts who can, use their expertise to get the best kind of annotations that they can put out. And I think that, I don't think anyone on this panel would suggest that people don't need access to the law, or that access to annotations isn't, an important mechanism for helping them to understand complex areas of the law. But I think that we have to take a step back and remember that access is not necessarily free access, unfettered access. Access can mean compensated access. It can access and copyright incentives do not have to be, again, going back to this dichotomy. It's another false dichotomy. Like what Karen was just speaking on, is that copyright incentivizes the creation of these very works that people want access to. And so again, these things work in tandem with one another, and they're not, against each other.
So let me try to frame I'm going to throw out a couple of questions that are all related, and they're all related to what you've all been just saying. Right, so and it has to do with the arguments raised by the justices in that decision, right? So one is the argument about economy class versus first class, and the question is, whenever you're talking about access, you're talking about access to what? What specifically? Same thing with regard to the incentives. Incentives to produce what exactly, specifically, by whom? Right, and I think the conversation often about incentives and access kind of talks as if we all are talking about the same one particular work We all have the same thing in mind. But in this case, what we're talking about is access to the annotations, access to the legal materials necessary for someone to generate annotations, access to data related to who accesses what and how they build upon the corpus. So that's one question, is so what exactly is the access and incentive argument we should be evaluating and trying to sort of apply? Second is it just an empirical question and we don't have answers to, right? Should the Copyright Office sort of do a study on the whether copyright incentives are necessary to induce annotative creativity? Right? What are the various means by which annotative creativity can be incentivized? Do you need copyright to be doing the work there, or not? And so I guess one of the things I'm confused about when I read the case, especially when I read all the different opinions, is I'm especially stepping back and thinking about social justice theories. Are the justices essentially all making the same consequentialist arguments, but they're basically just disagreeing about the empirics or the reality on the ground? Or are they making different normative arguments? Are their conceptions of justice different?
I'm going to take a first stab at one of your questions, the access to what question, and maybe the answer will bleed into the other questions. But so I think the court was very, very concerned about branding in a way that actually doesn't fit all that well with copyright law. It was worried that when this annotated code was deemed to be official by the state of Georgia, by the Georgia legislature, that people would somehow feel a need to access that particular set of annotations. One could imagine situations in which, because this is the official Code of Georgia annotated, that if you came before a judge and you didn't cite something that was in the official code of Georgia annotated, but it was in some other annotation, or if you did cite something that wasn't in it, that the judges would think that you were somehow out of line, because obviously whatever Westlaw is producing, that's not the official one. And so I do think the court was concerned about branding. It is odd, as Kevin says, it is decided as a decision about the statutory meaning of author, but the court is focused on authorship as much as a branding tool, I think, as the kind of copyright tracing who's going to get ownership. And that gives the opinion a slightly odd cast. But, again, going back to your question, access to what? I think the court, the Chief Justice would say, well, access to the things that the state itself is deeming to be the official things, which gives it some kind of imprimatur that suggests that the public really should be able to look at this.
I would agree with what Bob just said, in the sense that I think that the court made mentioned that, or stated that no one can own the law, and I think it was a narrow decision in that sense, in the sense that they did not suggest, the court didn't seem to suggest that state ownership generally of copyright somehow would not be permitted, but that in this particular instance, given the facts, this was more akin to the law itself, and so therefore there could not be any ownership of the law, because again, everyone has to have access to the law in order to be able to access justice more generally. And so I think that the narrowness of at least the majority opinion, I think, did go to trying to just figure out what should the bright line be between the incentive and the access piece, as well.
And the other, I just would add to that, and I think maybe this is sort of what I thought of when you asked your question. To what extent do we need to look at the nature of the work in deciding whether something is covered by the government edicts doctrine? I mean, the court, I think the opinion sort of it it literally says this is a straightforward rule that we're creating, and you don't really need to look at sort of the binding nature. It doesn't really matter if the annotations are kind of purporting to break new ground or anything like that. The fact that they were, written by a legislative body in the court's view in the course of legislative duties kind of puts them into this bucket of being authored by the legislature. But I think there is sort of a suggestion. I mean, the opinion does have a paragraph where it's sort of talking about the fact that, well, the annotations, do reflect sort of choices about, what the legislative council thought was important. It makes you wonder, this was sort of a case where something like the annotations, I think as lawyers, we can kind of appreciate that, you need, you never want to just cite the annotations. You'd always want to cite the actual text, but I think that there was certainly an argument that the fact that the annotations were ratified in some way by the legislature gave them some weight. But you can imagine, well, what if this was just sort of a resolution saying that, the official state song of Georgia is such and such, does that, does the kind of different nature of the work in that case matter? And I think, it's not totally clear. I mean, you can imagine cases, is everything a legislator does, speeches back home, for example, I guess you could certainly think of that as being within their legislative duties, but, there's sort of a spectrum along the line of legislative duties where I think maybe it becomes a little bit harder to tell. So anyway, the question of, to what extent does the nature of the work sort of matter in this analysis?
Yeah, and I think I'd like to go to the part of your question about whether it's sort of an empirical question around innovation or annotative expression and creativity. And I think that goes to Tarika's point as well about sort of what's happening maybe in Pennsylvania. If you don't sell the work, you're not going to get the work in the first place. But I think there are two things that really distinguish this particular circumstance, and I would say take it out of the empirical analysis. One is that, again, we're talking about information about the text of the law. So even if there isn't anything, I would prefer to have that situation so that everyone would have the same access, those who are well lawyered and those who aren't, to the law. Of course, those who are well lawyered are going to have additional interpretation, but everyone should have, to me, in my opinion, and I think I stand with the justices here, access to the same understanding of what the court and the legislature thinks the law is. To me, that seems extremely fundamental and important for the functioning of our legal system and the rule of law. So that's, I think, the first point. I think the second thing is also, when you're talking about government works, you're talking about works that have been created with taxpayer dollars. And so I understand the point that perhaps there's some works that the government's going to create and continue to have copyright and monetize it in certain circumstances, but it's not in the context of we're paid to create the law, and we create the law, and we should give you access to that. So I think, again, in this idea of paying twice, this is coming up a lot in the copyright in the patent context, where we fund R&D, and then the R&D is then sold to the public. So this is why I'm kind of tuned into it in particular. But it strikes me that if the public is paying for the creation of the work, then they should have access to it. And so, especially in the data context, that kind of philosophy has created the open data movement and allowed for there to be tons of companies and industry and civil society being able to use the data in an extremely generative way. So I think one kind of character we haven't talked about in the ecosystem, we've talked about consumers and we talked about creators, but also the reusers, right? And the recreators are also a really important interest group here. So if there is the annotations, then others can put it into different formats, make it much more accessible to a broader audience without that restriction. Now, again, if there are ways to have differential pricing, I know I keep on saying that term, but if there are ways to have people who are able to pay high amounts do that, I support that from a utilitarian perspective. But
Colleen,
yes.
let me pause. Let me interrupt you. Pardon me for the interruption. You've mentioned differential pricing 7 times. I'm glad you did. I think it's important. I suspect that some folks in our audience don't know exactly what you're referring to when you refer to differential. Many will, but can you just say what you mean by differential pricing and why it is something that is important for mediating for sort of figuring out this?
Thank you. Yeah, so I mean,
question.
differential pricing is basically the idea that the same good or service can be accessed by different bands of consumers at different prices. So the simplest example would be if you sell a book in the United States for consumers and you price it at a certain level, say Harry Potter hardback new book comes out 1995, and you also want to sell it in a developing country at a lower price. Say let's just pretend it's a developing country which also has the same volume, is not a different edition entirely, but you want to sell it to that audience because you can control the price. There you might be able to sell it for a much lower price, and in that way, the rich consumers will subsidize, in a sense, in terms of their contribution to the profit relatively, the poor consumers, but everybody does better because they both get access to the work. You create more access rather than having a single price, which then would, cut out a certain segment of the consumer base. So having different audiences pay different prices is kind of the basic idea.
Can I suggest that that's exactly what probably is happening here with this result, given this court, even though neither the court nor the dissent acknowledges it? Because what's actually happening right now that public.resource.org's scans of the official Georgia Code of Georgia Annotated are up on Internet Archive, but Lexis is providing its version integrated with a whole suite of search tools, of hyperlinks from the annotations directly into the opinions, and all sorts of note taking, the whole thing we know about what happens inside Lexis, right? So what's happening is Lexis is still able to provide the official Code of Georgia Annotated in a somewhat enhanced version at a much higher price. You have to subscribe to Lexis. There is a less enhanced version, an economy class version of the annotations available on Internet Archive. Most lawyers will not go there, and I went there, and the number of visits to those volumes on Internet Archive is very low. Because they want the higher class version. They're willing to pay the differential price for that higher class version. And the people who are going there probably are the people who can't afford Lexis, but they still do get access to the annotations. They just don't get it built in with all the functionality of Lexis. So what that means is that, oddly enough, although the court is worried about economy class versus first class access, actually the opinion ends up creating something like that. And possibly, although the dissent, Justice Thomas, is worried about a lack of incentive to create the official Georgia Code of Georgia Annotated, we have to see. I think that really is an empirical matter. And I think it's possible that the subscriptions to Lexis and the desire of Lexis subscribers to have that annotated code will be enough to incentivize Lexis to create it, even though the dead scans without any links, without any other functionality, are available in the Internet Archive.
Right. So there is a rich, detailed literature in economics and law and economics that goes into all of the different business models for price discrimination, differential pricing, a variety of different models. And what you're describing is partly something that's not just a straight, the same product offered to different consumers at the same price, at different prices based on their willingness and ability to pay, which is what straightforward differential pricing, value-based differential pricing would be. But you're actually creating genuinely different products based on access to the underlying input, right? Which is the initial code and
well, right.
Although the initial set of annotations.
The differential part here in the different product is the functionality, the search and other functionalities and hyperlink functionalities. Like, not the
Right.
content
Right.
of the
Those-
annotations, which is the same whether they're up on the scan. Yeah.
Yeah, it's great. So there's a bunch of add-on services that you can kind of add on and then attract higher value, people who are willing to pay more to get access to it. So this gets debated in patent law and the Bayh-Dole Act for decades, right? Whether or not you need exclusivity, or whether or not patent-enabled exclusivity for someone to build on innovation to commercialize. And so this is just this debate we're having, and I kind of want to move us off the Georgia case, although we don't need to if people want to keep talking about the Georgia case. But it's actually a good example of something that sort of perpetuates all of IP, right? So all of IP has these kind of conundrums where it's about these access incentives, price discrimination. There are some downsides to price discrimination, which we really haven't talked about, but we can leave those aside for now to move on. But if we want to move beyond, and I kind of want us to move beyond because we have under a half an hour left, and I want to make sure we open it up for, okay, there is one, there's two questions in the Q&A. I'm terrible at doing multitasking, so I wasn't actually monitoring the Q&A as much. All right, so the first question I think we're going to leave more towards the end. It was asked earlier, but I think it was in response to our initial discussion. And so it'll make more sense maybe at the end. Mitch asks, if Georgia could assert copyright over the annotations, does that imply it can discriminate in who can access them and at what price? So this relates to the conversation we were just having. Does copyright law itself have anything to say about that threshold or about the pricing? I'll just throw that out to the panel as I look to shift us. Any responses to Mitch's question?
Sorry, it's really noisy in the back of my house, so I apologize. But I think the gist of it is that, yes, that if you have copyright, you can change the price you pay, at least in theory. But the reality is, how do you actually differentiate between consumers? Unless you have them sort of means test or somehow qualify their income level or something, discrimination can be very difficult, right? Unless you have certain channels by which you provide it. But I think having copyright does give you the ability to discriminate. And that's why I think it can be very positive for increasing access, because you can charge people at different levels. If you didn't have the copyright, then it would be harder to control potentially.
Right. You just buy up the data, though, Colleen. Increasingly, you just buy up the data so you can price discriminate, because you have lots of detailed information about each and every one of us. That's a whole different panel discussion. We can have that later.
Then, however,
now, let's move
prevent
on.
arbitrage, right? You need to prevent somebody finding somebody with the right data to get access and giving it to somebody else, right?
And letting them exchange between themselves. True. All right, so let's move beyond the Georgia case to adjacent scenarios and cases, right? So there's a bunch of situations, some of which I know Kevin is familiar with, and so I want to sort of tee you up, Kevin, to sort of say something about this, and then it'll open up to other context. But there's other situations where the state adopts law into standards that are authored by private entity. You mentioned this very early on in your talk. I'm going to return it to you. So what is the state of the law regarding the copyrightability of privately developed materials that are then adopted or incorporated by reference or otherwise relied on?
Well, I think the state of the law is somewhat unclear. Prior to the Georgia case, there have been a number of cases at the circuit court level dealing with privately authored materials where the government has somehow ratified them or adopted them. So there's a case in the Fifth Circuit 20 years or so called VEC, which involved model building codes that were written by, these sort of professional associations, code standard development organizations, mainly comprised of, engineers, state and local officials, that in this case were later adopted as the local building code by a couple of municipalities in Texas. Someone posted them online. The code development organizations asserted copyright, and the Fifth Circuit said that there was no copyright, at least insofar as they were adopted as law. And the court sort of articulated, a couple of different potential rationales for that decision. One of which was the Merger Doctrine, which, of course, says that which is related to the fact expression dichotomy. But essentially, if there is only one way to express something, then copyright does not protect it, because it would effectively give the copyright holder a monopoly over the idea. And the idea was, again, sort of as we all know as lawyers, there's only one way to cite the law itself. And so when something was adopted as law under merger, it's no longer copyrightable. There are a couple of questions, and I don't want to dwell on that case. I mean, there are a couple of questions that arise, though. I mean, one is that normally, merger typically is measured at the time a work is created. The question that, certainly we've said in the Copyright Office is, okay, at the time the work was created, is there sort of a limited universe of ways to express something? And if so, it's a copyrightability question. The work is not copyrightable. This scenario is a little different, obviously, because the works obviously were at one point in their history copyrighted, and it was the state's action later that was held to take away the copyright. So in some ways, that doesn't feel like merger. There have been other cases where, for example, the action by the state was a little bit less direct in terms of making something binding or making it official. There was a case in the Ninth Circuit around the same time where, the state had said that for insurance purposes, providers were supposed to use a coding system that the American Medical Association had issued. In that case, the court said that the coding system did retain copyright. There was sort of there's sort of a continuum in terms of what the state can do in terms of adopting something. In that case, it was sort of not incorporating it by reference, but directing that, people use this guide. Just to circle back in terms of the doctrinal issue, I mean, some people would say, well, shouldn't fair use cover this? Maybe these materials are copyrightable, but it should ordinarily be thought of as a fair use to make whatever use you need to, insofar as they're legal edicts. And that could be, a theory. The problem with that is, it's hard to think of something that would be an unfair use. In what circumstances are governments still allowed to assert copyright over something if we're saying it's copyrightable, but it can be used as a matter of fair use because we think it's important for people to be able to use the law. And I think one thing to think about is that sort of just a theoretical concern, or does it really affect kind of how we treat these various things in terms of whether we think they're not copyrightable at all once they're sort of adopted by the state, or they're still copyrightable, but we're going to give sort of a wide berth to fair use, and pretty much every use, or the vast majority of uses, are going to be considered fair.
Well, Kevin, listening to you reminds me of when I used to teach. I haven't taught copyright in a few years since I moved to Villanova. I will soon. But it reminds me, when I used to teach, I used to talk to students to use the metaphor of Swiss cheese. Copyright's like Swiss cheese, and there's these big holes in it. Some of those holes are fair use. Some of those holes are merger. Some of those holes are idea expression. Something falls out of the lattice of the cheese, and that's where the open access. Anyway, don't mean to beat the metaphor to death, but right. So the idea of whether authorship, fair use, merger, idea expression, or fact expression sort of doctrines are the best way to mediate these access control or access incentives questions are particularly difficult with the case of these things that were created by private entities and then later adopted by the state in one form or another. A lot of the concerns you raised remind me also of when I used to try to teach not necessarily effectively, software and copyright. So the doctrinal application of those very same doctrines in the context of software often runs into exactly the same set of issues that you just highlighted. So What I want to do is to shift. What about other adjacent scenarios where are there things like, well, actually, to save us time, I'm going to jump past this question about libraries and open source software. Let's circle back to the big theme, reconceptualizing the rights holder IP consumer symbiosis. Right, so I want to open up the discussion among the panelists, and so there's a couple of different themes that I want us to touch on before we close. And one of them is this dispelling the rights holder public misconception of the IP in a post-pandemic IP social justice. Tarek, you've noted that the vast majority of creators, you noticed this at the very beginning, and you and I talked about this before, the vast majority of creators are everyday people, right? Can you say a bit more about that and how that absolutely true fact, all of us on this panel, everyone taking notes, all the audience, we're all creators in the sense that we're getting copyright protection for the expression we create. How does that fact lead us to
well,
think
I think it ties back
justice?
into something that we've touched on several times, the incentive structure of copyright, and recognizing the importance of that incentive structure, and recognizing the value that copyright plays in affording access and creating these important works. And so I think when you take a step back and you realize that the people who are actually creating these works, for the most part, the vast majority are people just like you and I. They're everyday people. They're our neighbors. They're our friends. Every creator is not Beyonce. They're not all millionaires. They're not all celebrities, living lavishly. A lot of them are just normal everyday people. And so, I think it's important to humanize that side of things, because I think people get comfortable with infringing certain works and not, respecting creators a lot of times, because I think that they have this vision of, all creators are big corporations, or all creators are, super rich celebrities. And I think when we take a step back and really, look at the truth there, which is that the vast majority of them are just regular everyday people, some of them, working class people, we see that copyright as a financial structure and as an incentive structure actually helps to empower those people to be able to create a variety of different works. This is something that Karen touched on at the beginning, and this is something that I say a lot. There's value in having a diverse set of creators. There's value in having people who come from modest backgrounds or come from low income backgrounds, just as much as there's value of hearing from people who come from wealthy backgrounds. But if we get rid of that incentive structure, we're going to only hear from people who can afford to have a full-time job as a creator, those who can afford to give their works out for free. And I think also I want to touch on the fact that the notion that works should be available for free, or the notion that creators don't deserve to be compensated for their work, I think it comes from a place of privilege. It takes a very privileged position to suggest that the work that someone does, they should not be able to afford to make ends meet. They shouldn't be able to afford to, pay their bills and eat. I mean, you can't eat exposure. You can't eat attribution. You have to make money, and we don't treat other professions that way. And so I think when we take that step back and really acknowledge that creators are just like everyone else out here trying to make a living, they just so happen to do jobs that might be more fun than a lot of other people's jobs, and maybe that's a little bit envy there, but they deserve to be respected and treated just like the rest of us.
So Tarek, let me, and then this is for the whole panel, but I'm going to jump off of what you just said, like build off it, I think. So if we think about the relevance of copyright for enabling widespread user creativity, whether to be a creator that makes money, or whether to be a creator that just creates for fun as an amateur, copyright, how does copyright work to enable that kind of creativity? Like, what role does copyright play? I mean, we talk a lot about incentives, but incentives is such an abstract thing. Most people who sit down to write a book, a novel, a song, paint something, aren't thinking in the sort of rational economic sort of actor model where they're kind of going through some kind of incentive calculus in their mind, right? They're doing things. They sit down to do things, and copyright plays a different role in sort of enabling them to participate in society. So can you guys say a bit more about what that is so that we can move beyond incentives and move into copyright enables, I mean, even open source people, right? If you're an open source person, or I'm doing an NSF project and I got to make my publications openly accessible, I'm going to use copyright to enable me to do open source licensing. Creative Commons licensing is built on copyright, just as an example. Can you guys say a bit more about how copyright enables more than just
I again,
some abstract notion of
definitely
incentives?
agree with what Terica just said, in terms of the economic incentive aspect of it, and going back to making sure that copyright does enable a diverse amount and type of creativity. And in terms of the, kind of the real world example of the economic incentive of copyright, just taking the example of the author you said, who doesn't, sit down and calculate that incentive in their head, but an author who wants to be an author as a career will have to pay their mortgage. And the only thing that would allow them to pay their mortgage potentially might be that advance that they get from the publisher that allows them to devote themselves to a year or 2 years to research and develop their novel. And so that economic incentive, so to speak, is more than just an incentive. It is actually enabling them to create, at all, because they would not be able to have that ability to create if they didn't have their bills paid. And so I think it is as fundamental as that. And so, I also agree with Terica that sometimes it comes from a place of privilege to suggest that artists or creators should not be compensated, or that piracy is not harmful, because it suggests that people who have to rely on the compensation for their work should not be able to do so. But that instead it should be just the major corporations or just the wealthy who are able to take a year off and write a book. And that, to me, would be a disservice to the general public, because again, you wouldn't have that diversity in terms of creativity, because you would be limiting it to only those people who would be able to afford to be creators.
Yeah, and if I could just piggyback on that, I mean, going back to your example about, the author that sits down to write the book, I think oftentimes we focus on that moment when they sit down to write the book, but we don't talk a lot about, well, what happened, the 5 years leading up to that? Did they go to school? Did they study? Had they written 10 books before, and now this is the big book that, those 10 books allowed them to, hone their craft, and now they have a marketable piece of work. It takes, there is some degree of something that they have to sacrifice, whether it's in that moment when they're sitting down to write the book, choosing to give up time doing something else, or choosing to, give up a certain career to do this. But oftentimes there's just so much that goes in before we even get to that point that, requires some degree of sacrifice, which you need an incentive to produce.
Oh, absolutely. So the idea that there's a lot of ex ante, labor and investment in time and resources that people devote to being authors. So this is where I think, Colleen, you mentioned it earlier, right? Jessica Silby's book, where she interviews all kinds of different creators in a whole bunch of different industries and talks about exactly the stories that you guys are the set of scenarios you're talking about in a very useful way. It's worth sort of referencing her book for that. I was really just pushing on. I agreed with all that. I'm just pushing towards the additional things, right? When you've got your story, in order to get that agreement to get paid from the publisher, you actually have to establish a relationship, right? It enables you to contract and form relationships with a whole series of people in a supply chain who aren't necessarily authorized, authors or creators, but they require you to have something to work with, essentially. That's all I was driving towards. And so that's what the reference to open source licensing was, to say, even if you want to make your stuff freely available, oftentimes copyright.
I just wanted to add to that. I mean, I think that is an important point.
So Colleen, I know
some people think that copyright somehow prevents you from doing that, prevents you from making your work available. And yes, it allows for flexibility and choice. So those authors who do want to monetize their works, or those creators who want to monetize their works, copyright allows them to do so. And again, there are many authors and creators who do need to monetize their works in order to be able to, again, make a living, pay their mortgage, feed their families. But for those authors who do not need to monetize their works, if they want to make their works available more freely and for example, just get credit or attribution, copyright allows them to do that as well. And so it's not a barrier in terms of how people want to distribute their work or make their work available publicly.
So Colleen, I know you wanted to say something. You have some interesting thoughts that you wanted to express about thinking about the different kinds of inequalities that we should be talking about.
Yeah, I mean, I think within the framing of what we've been
sort of
discussing, again, the idea that it's not a dichotomy between uncompensated versus compensated, right? We all want inclusive innovation, and we all want it to be easier for sort of parties to be able to find each other to make that happen. So I think ultimately, ensuring that those who have talent and want to participate can do so is really important. I think, again, on the front end, copyright does a great job because you don't have formalities unless you decide to register. But then I think to one of the points in the Q&A, the enforcement side has been more difficult to access. And now I think we can talk about, if people want to, the CASE Act and whether that is really going to democratize enforcement to some degree. But I think the other point is really, okay, we'll get there, right? But I think the other part is that that's,
question.
Sort of,
you got it.
Ensuring there's inclusive innovation, but then it's making it easier for parties to actually transact. So I think, making sure the market actually works so that people can be compensated in the presence of copyright, that there actually can be compensation that flows back to the author at different levels, right? Going back to my earlier point. And again, I'm curious about what different initiatives the Copyright Office or others are working on to, try to create more ways for there to be micropayments or bigger payments, other ways of. It seems like those are burgeoning to have various levels of compensation, because as we said, Terica, not everybody's Beyonce, not everybody is is going to be needing a full income from copyright, but still wants to get some, maybe, and continue to grow that. So just understanding better those models, I think. I would certainly learn from that.
So before we jump to the CASE Act, I think Colleen just asked Kevin a question.
Those are things the Copyright Office is doing to encourage.
Yeah, I see that green papers and
yes.
The different the different project white paper going into different phases of thinking about licensing in particular. I was just curious.
I mean, my instinct is to defer to Karen, but I guess I can't do that anymore, unfortunately. So I'll have to try this myself. I mean, I think we're doing a lot. Certainly, the CASE Act is something that certainly small claims generally is something that the Copyright Office has long been encouraging and advocating for. And so we're certainly think that is something that would really help small creators be able to enforce their rights. We're in the process now of implementing the Music Modernization Act, and a big part of that is outreach to really make people aware of what the law does and the sort of opportunity to get paid more easily and the mechanisms that now exist to make that happen more smoothly. I think just from our standpoint, we are trying to modernize our own systems. And, a big part of the driving force behind that is to give people opportunities to sort of smoothly register their works, to record documents with the office. I mean, since COVID has started, we've actually issued some regulations to to provide for electronic submission of documents. So, I mean, you're absolutely right. It's something that, you know, we are thinking a lot about and trying to work on a lot of fronts.
Let me just add with regard to the Music Modernization Act that it also anticipates that or contemplates the creation of this database, right? This huge database of musical works and who owns them. And, you know, creation of that kind of organized, easy to access information is a huge enabler with regard to transactions.
That's great. Good point. So there's one thing we haven't talked about. We talked about a lot of things. There's one thing we haven't talked about that that was on our call, I guess. We haven't talked about COVID much, right? And frankly, I'm inclined, given the theme of the conference and its emphasis on social justice, as always, to broaden the inquiry to include climate change and other major threats or social dilemmas for which IP is one important driver for the development of solutions. So after all, I mean, our panel description suggests we will discuss how the IP ecosystem will enable social justice in a post-pandemic world. For me, at least, the one of many things that this COVID pandemic is doing is revealing all the things we take for granted and all the things we might want to change, and the need for that. So I want to open up the discussion for last. We have 3 minutes left, so let me just open up for the panel to discuss what we've learned about IP during the pandemic and how those lessons might be useful in addressing post-pandemic social justice.
I mean, I'll start just to let
the takers.
Better answers go after me, but I think certainly in thinking about patents and innovation more broadly, the need for coordination and the desire to really be working together, particularly around vaccine or other research, is really pressing. So I mean, I think on the copyright side also, thinking about the collaborative nature and the interactions. People are at home watching content at a level they never have before, so it becomes so important to be able to connect through wonderful content. I think we all appreciate that, but to be able to access it not only from the big players but other smaller creators, I think is really important. So there's a lot of, I think, think about the payments. We're all making more payments probably to copyright holders. But it's mostly going through, as has been said before, the large corporations. And what about all the other content that we're, absorbing, but we're not necessarily compensating for? So I think that's an interesting set of questions around, as we consume more content, who's actually getting paid for it, and how do we ensure that there is more equity along that chain?
We haven't even talked about TikTok creativity, but anyway. Other takers on the question? Post-pandemic social justice. What have we learned? What are the lessons?
Well, I'll jump in on this one. One thing that I've noticed throughout the pandemic is, as people have, dealt with job loss and looked for other ways that they could earn income. One of the things that I've been really excited about seeing is the number of people who are turning to some form of creativity in order to make money during that time. And so I think, as we look forward, I would hope that people begin to look at copyright for the way that it empowers people, the way that it, enables people to use their creativity and turn that into financial, freedom. And so that I hope that's something that we can take moving forward once we get past this.
All right, I think it's 4:15. I think it's 4:15 in the East Coast, 3:15 there. Colleen, Karen, Kevin, Bob, Tarika, I want to thank you all for a wonderful conversation. I had a lot of fun. I don't know if you guys, I had a great time talking with you guys.
Thanks, Brett.
Hope we can do it again.
Thank you.